From South Carolina is recognized.
Thank you, Mr. Chairman. Mr. Horowitz, your office published advisory memo 24-067 entitled "The Justice Department's Compliance with Whistleblower Protections for Employees with Security Clearance," and noted how you found that the DOJ was not in compliance with whistleblower protections for employees with a clearance. Is that correct?
That's correct.
What policies exactly did the DOJ fail to follow?
So the law requires for suspension and revocations of security clearance that the department have an appeal process allowing, after 1 year of suspension, to come to the Inspector General and appeal that process. That was not in place at the time.
Does it concern you that the DOJ, that certain DOJ components like the FBI indefinitely suspend employees without pay for the duration of a security investigation and review process?
It does, which is one of the issues we also raised in that management memo.
What is the average length of time for one of those investigations?
So we found in the report that for the 106 employees that we looked at over a 5-year period who had been suspended for more than 6 months, that the average was 527 days. So about 17 and a half months.
So about a year and a half, roughly.
Year and a half.
So in your work, have you seen similar delays or similar lengths of time in other agencies?
We have within the department in other components, law enforcement components.
What concerns me too, at least with the pay issue, the DOJ and FBI's current policy forces employees to remain in kind of an indefinite state of limbo without pay.
That's exactly right, and that is the concern, Congressman, that goes actually beyond whistleblowers. Mr. Allen ultimately was able to get a settlement because he was a whistleblower alleging retaliation, but that same issue applies to people who don't have a whistleblower claim but have nonetheless had their security clearance pulled.
I just think it's remarkable to me, I mean, just to hear Mr. Allen's testimony earlier about what he and his family went through. Mm-hmm. Pulling out retirement, life savings, things like that, just to stay afloat. And fortunately for him, he was able to settle, but he might be the exception and not the rule. Is that fair to say?
That's correct. Many people we've seen have resigned or retired rather than wait 2+ years.
Can I add one clarification on the settlement? It was not because of his whistleblower claim, or the settlement's related to that, but the restoration of his security clearance was because of just an appeal of the revocation. So that was not tied to the whistleblower claim or to the settlement for the back pay. The FBI explicitly said, we're not giving you back this clearance just because there's some settlement. They make an independent security determination. They determined he was entitled to it.
Correct.
Thank you. Furthermore, the memo found that DOJ policy doesn't hold the legal requirement, to the extent practical, that permits an individual to retain their employment status while their security clearance is in review. Is that correct?
That's correct.
Does the DOJ's failure to follow this policy concern you?
It does, which is what led us to issue the management alert. The department did respond and has since changed its policies so that there is that 1-year appeal. The other thing that they've done, which is not required currently, but is certainly something that I think Congress should consider, is requiring components, department law enforcement components in particular, to consider whether there are paid jobs people can be in without the clearances, even if a clearance suspension is warranted, so that you don't have this situation where someone gets put out unpaid leave or paid leave not working either, which has been another problem, by the way, at the department over the years, is putting people on paid leave for extended periods of time, so they're getting a paycheck without having to work.
Based on your office's findings, do you think that the senior leadership within the DOJ or the FBI were aware that their policies did not follow federal legal standards?
I actually, my sense is they were not aware, because when we started this process and went to them, they did not seem to know about this issue, or weren't aware that their policy fell short on that issue, I should say.
Your office made 4 recommendations to the DOJ to address the concerns cited in your memo. One, what were those for the record? And 2, to your knowledge, what steps has the DOJ taken to implement those recommendations?
So the 4 recommendations were: 1, to make sure there was this 1-year appeal process; 2, to notify employees of their right to this process, because obviously you can have a process, but you shouldn't have to have an employee rummage through a lot of policies to find it. Third, when there is a suspension, look to see if there are positions they can go into where they can continue to maintain their position while performing work, even without the suspension, if that's the plan. And then fourth, put in place a review to make sure that these are being done timely. And so, because you don't want a situation either where if they can find another job with a security clearance suspension pulled, that they somehow indefinitely stay in that other job. You want them to have that resolved. If they shouldn't be in the job, they should leave, right? Then if it was an unfair suspension, they should be put back to their old job.
And have they taken those recommendations?
They have,
taken those?
and I think very importantly is the requirement that they report regularly to department leadership as to why that hasn't occurred in a timely way.
Thank you, Mr. Chairman. I yield back.
Gentleman yields